Welcome, friends. Welcome to Legal Breeze. Today we will be discussing about the Prevention of Money Laundering Act. What is its importance? What is its constitutional background? Recently, Supreme Court has upheld its constitutional validity. What is the reason for holding it as constitutionally valid? All these things will be discussed in this particular video is concerned. First of all, let us understand what is money laundering. What do you mean by money laundering? Money laundering means conversion of black money into white money, conversion of illegal wealth into legal wealth. So that is what called money laundering. Say example, we have a cloth which is dirty. But once it is washed, it is usable. Once it is laundered, it is usable. The same way, when the money comes out of illegalities, that cannot be used directly. So it has to be laundered, it has to be legalized through several processes. That process is called money laundering. What are all the stages? These are all not covered in law, but these are all given in the economics. So that's very important. People call it as placement, layering, transfer, then final usage. So these are all some of the stages in money laundering. Placement in the sense, the person who wants to use the money, once he created through illegal means, generates the wealth through illegal means, he cannot directly use it. So what he has to do, he has to put it in the accounts of someone else through several installments, because otherwise people can identify it. It's a chain of transaction, series of chain of transaction. It will be transferred to someone else. It will be going through other countries. From that country, say example, from India to Pakistan, Pakistan to Afghanistan, Afghanistan to Russia, Russia to America, and after America to Seychelles or Cayman Islands. From there, it will come back to India in some other way. Then finally, the same fellow who has initiated the transaction, he will use the money. Some people call this as a round tripping. So these are all there even in tax evasion, like double taxation, tax evasion, particularly international transfer of pricing mechanism, all these things. So this is an organized crime. That's also very important. You all should understand it. Why this has to be there? What is the problem? This is a parallel economy. It cannot be accounted in economy. It cannot be accounted legally in GDP. Therefore, it threatens the very fundamentals of the macroeconomy. So that is the reason every country is very serious about it. What is the constitutional background, or what is the constitutional mandate? We have a provision under Article 39C. It speaks about prevention of economic power in the hands of few. This is also one of the means to prevent it. By attacking money laundering, you are decentralizing the concentration of economic power in few hands. And 39B is also somehow indirectly connected with this. Welfare state activities, indirectly connected with all these things. Above all, we have a few international treaties to which India is a party. First one is there is something called UN Convention, particularly Vienna Convention on illicit trafficking. You may ask me what is the connection between illicit trafficking and money laundering. Illicit trafficking is an important means through which money laundering takes place. So that's very important. Then there is another convention called Polymer Convention or UN Convention on organized crimes. That has been concluded way back in 2000. And in addition to this, we have certain action called FATF, Financial Action Task Force, FATF, that is promulgated or formulated by G7. So India has an obligation to fulfill the aforestated international commitments. And that is why in the year 2002, Parliament of India has enacted this particular piece of legislation called Prevention of Money Laundering. In 2000, post 2016, this has been tightened too much when Varun Jaitley happens to be the finance minister. Certain challenges have also been made in the year 2018, particularly Section 45 of this Money Laundering Act, which imposes twin condition for bail under the Money Laundering Act. At that point of time, 2018, in Nikesh Taru Chandra versus Union of India, Supreme Court has made it Section 45 of the Money Laundering Act as unconstitutional. But again, to cure the defects, Parliament has made certain necessary amendments. Now it has been upheld by the Supreme Court in a very recent landmark case. So only that case law we are going to discuss it. What is the contention? The petitioner have contended Section 3, Section 4, 5, 6, Section 17 to 19, 24 and 25, 45 are unconstitutional. However, Supreme Court has held all these provisions are constitutionally valid. Section 3 defines what is money laundering. It defines as an offense, makes it as an offense. Proceeds of crime, that's very, very important. All of you should understand it. What is this proceeds of crime? Any wealth created out of illegality through illegal means, and sometimes means may be legal, but the activities or the end result can be illegal. Even then, it is treated as proceeds of crime. So that will be sucked back through the Money Laundering Act. It cannot be channeled. You cannot put the proceeds of crime the normal channel of economy. It will be destroyed. Say example, you would have heard about smuggling narcotics. They will dispose it. Once they confiscate it, they will dispose it. You will not be allowed to sell it. The same way, the wealth will be attached by the government action. Another important thing all of you should understand it, the difference between FIR and ECIR. FIR, all of you know that this is coming under section 154 of CRPC, whereas ECIR is defined here in the Prevention of Money Laundering Act. This is a report developed by the Enforcement Directorate. You may ask me, what is ECIR? Enforcement Case Information Report, ECIR. Now, though it is similar to FIR, but the background is different, players are different. Therefore, the Supreme Court says FIR should be given to the accused. Copy of the FIR shall be mandatorily given to the accused. Whereas they say it is not necessary. At the time of arrest, the ED officials are mandated only to disclose the grounds on which the person is arrested. At the time of charge sheet, maybe it can be given to them. That's a major difference between ECIR and FIR, and the provisions relating to ECIR has been constitutionally made valid or upheld by the Supreme Court. Then comes the statement made before these ED officials or confessions made before the ED officials, whether it's valid or not. You all know under section 25, 26, when you are making an confession before the police officer, it is inadmissible as per the Indian Evidence Act. Whereas here, it is valid. The confession made to the Enforcement Directorate officials, Act makes it valid, and Supreme Court also upholds the constitutional validity. Then burden of proof. Burden of proof is given to the accused rather than on the prosecution. This is also agreed by the Supreme Court. Then section 45, there are two conditions for getting a bail. First thing, the person should clearly prove that he is not done the offense to some extent to get the bail. He is not at all guilty. Second thing, he should prove to the satisfaction of the court, if he is released, he will never indulge any sort of offences pertaining to this money laundering or tampering the evidence and other conditions. If he demonstrates that he will fulfill these two conditions, then only the bail can be granted. So these are all the important information all of us should keep remembering. So money laundering is very, very important because this is a major source for organized crime, terrorism, etc. If you curb this illegal wealth, it can be terrorism can be prevented. Even criminalization of politics can be prevented. Organized crimes can be prevented. So technology can be used. That is also very important one. Technology can be used uh, very effectively, both in the digital as well as non-digital environment. Today's cryptocurrency becomes a major challenge because this is also one of the means to convert the black money into white. So people are working upon this, how to do about all these things. People are working on this. I think people will find some technological solutions as well as legal solutions. Previously, our legal regime did not address this crypto, but I think now we have at least some tax can be imposed upon them. 30% blanket tax is made applicable on all the transaction pertaining to crypto is concerned. So we hope the concerned stakeholders will work effectively so as to prevent the money laundering. And once you prevent it, I think we will get a good economy. Good economy will result into sustainable development, inclusive growth. Thereby, poverty can be elevated, and whatever our constitutional framers have dreamt upon will come to reality. God bless you all. Jai Hind.